Court is open.
Next case on our list this morning is number 2022-0741 in the matter of Ralph Parker Christie.
Good morning, Your Honors. My name is Tim White. I'm here on behalf of Chris Chetwin, and thank you for the opportunity to address the Court. General Laws, Chapter 190B, Section 1102, sets forth the purposes of the MUPC, specifically that the MUPC's primary purpose is to make effective the intent of the decedents in the distribution of their estates. Now, before addressing the evidence relevant to what Mr. Christie wanted on January 30th, 2017, for the distribution of his estate, I want to briefly address the issue of who had the burden to prove the presence or absence of undue influence.
Before you dive into that, can I just ask, why is that issue ultimately important? Because it's important in sort of one of two situations. One where there's no evidence, and the question is which party failed to produce evidence. And it's also potentially determinative if there's exactly 50-50 evidence and you need a tiebreaker. Here, there was lots of evidence on the undue influence issue, so it can't be the first. So I understand you want a legal issue, but why is this legal issue important?
Well, I think what I would do is two things, Your Honor. One is the reference the Urban case, that even if there was undue influence, as suggested by the Court, that the presence of independent counsel stops that and precludes the finding of undue influence. So that's one thing. The second thing is, as I get into my argument, I will suggest to the Court what's really relevant here is what was Ralph Christie's mindset on January 30th, 2017. Because the undue influence, for it to have occurred, had to occur prior to that for it to be relevant to this inquiry. So for those two reasons, that's what I would say. So as a matter of law, did the trial court err in assigning the burden of proof, which normally rests with the objector, to the petitioner? Well, the lower court concluded from the evidence that at the time the will was executed, petitioner had become a fiduciary of Mr. Christie. Now, I'm going to rely primarily on the arguments in the brief on this part of it and address more of what the Court just asked. But I do want to say that if you look at what was going on in 2016 and early 2017, at or before the execution of the will, does not support this ruling, and in fact, it contradicts it. Mr. Christie was living independently in his own apartment, executed his own lease extension. He paid his monthly rent and his monthly bills, and he managed his own finances. The petitioner was not on Christie's bank account at this time, nor was he a co-signer of the lease. Now, the springing power of attorney that was executed on February 24th of 2016 was never used prior to the signing of the will. And the recent Urban case states that simply holding a durable power of attorney is not enough and must be, quote, fully involved in all the undertakings relative to the revisions of the testator's will, close quote, and must have, quote, exercised unrestricted and expansive power over the testator's finances, close quote. That's what makes somebody a fiduciary. In the Moretti case, the Sharris case, the Michaud case, in all of these cases where the individual was found to be a fiduciary, the evidence established that he had taken total control of the testator's finances before the document was executed. And there is no evidence here to support that conclusion. The lower court erred in this ruling. Now to get back to Your Honor's question. I want to turn to the question whether there was a solid foundation of fact to warrant a finding that Chris Chetwin exercised undue influence, the standard established in Neal versus Brackett. Was the January 2017 will the product of Ralph's free will, as he told the attorney and the two witnesses on that morning, or was it the product of undue influence? By January 30th, 2017, was Ralph Christie coerced into doing something that he did not want to do? Because that's the standard. Did not want to do. Or was the will an expression of Ralph's appreciation for the undisputed and significant kindnesses, care, and love showered on him by the Chetwynd family during the previous 3 years of his life? So what was the solid foundation of fact, as the court asked? When did the undue influence happen? It had to happen at some point. How did it happen? What was the undue influence? Well, none of these questions were answered by the lower court. It simply came to the conclusion that it happened. But the evidence establishes that it had to happen sometime between February 24th, 2016 and January 30th, 2017, when the will was. Why? Because on February 24th, 2016, when Ralph signed the springing power of attorney, he told Attorney McWilliams that he was all set when it came to his will. So as of February 24th, 2016, Christie had a good enough memory to know that he had a will in place, and two, more critical to this court's analysis, that he had a strong enough will to say, no, thank you, I'm all set, and not be swayed by petitioner's alleged undue influence. Now, given that Chris Chetwynd worked a full-time job during this period of time, including Saturdays, the only time the undue influence could have been levied in 2016 would have been at night or on Sundays, most of which was family time and mostly included children. Given that Ralph lived independently in his own home and Chris was married, raising 2 kids, volunteering in his community.
Counsel, the arguments you're making are mostly fact-based. These are the kinds of arguments that were made to the trial judge who ultimately found the other way. Since these questions ultimately are questions of fact, what are you saying we should be doing as appellate judges?
Well, so what I'm saying is this, is that these are all facts, are all undisputed in the record, as part of the record that is before the court. So I'm not arguing that the court made a ruling that Mr. Chetwynd did not coach his children, did not volunteer in his community. Those rulings weren't made. Those findings weren't made. I'm not asking you to contradict.
What relevance do those findings have, did those particular undisputed facts have with respect to the judge's ultimate findings?
I'm sorry, I missed.
What relevance do those findings have with respect to the judge's ultimate findings?
So I think that they have a specific relevance to the element of whether or not Chris Chetwynd had become a natural object of Ralph Christie's affection. And I think the overwhelming evidence is that he did. And that these are the facts that show it. I mean, we're talking about, again, whether or not undue influence occurred, and there was only, simply a limited period of time when that could have happened.
Okay, but where is the relevance there? In other words, undue influence can happen in a very short period of time or over a lengthy period of time. That's not really the issue before us. The issue is whether or not, notwithstanding the fact that, assuming even the judge erred in terms of assigning the burden of proof, whether or not there's any of the facts that she found were clearly erroneous or against the weight of the evidence, or any other kind of principle you might want to pick.
That's exactly what I'm saying, Judge, is they were against the weight of the evidence as to what occurred from February 24th, 2016, up until the time of the signing of the will, was that there was an extraordinary amount of interaction between the Chetwynd family and Ralph Christie. And I could, with the time limits, and as you set up, I'm not going to retry the case, but between bringing him to his Masons events, attending the kids' baseball games, softball games, 2 Red Sox trips. Now, on August 10th, 2016...
Let me interrupt you. Yes, all those facts are true, but the judge found that, based on her credibility of the witnesses before her, that those were not necessarily interactions that were as independent or simply out of the kindness of your client's heart. She found otherwise. Correct?
I don't think she did, Your Honor. I think she simply said that these things happened, but, was this the strategy of undue influence? Is we're going to smother somebody with love, care, and kindness And is that something that, a precedent we want to set, that if that happens and somebody decides to leave
Well, I
you
think
in
you're
their will?
ignoring at the same time, there was a number of expenditures that were made, use of a car, a personal loan, one loan obtained for a former boss or supervisor, another substantial loan taken. Those are the other facts that were
So
undisputed in this case, correct?
I think that it's an important point that the court brings up, and that is, you want to talk about the loans. Well, first off, the loans were formalized in writing. Why? He didn't have to.
But this, again, to Justice Milkey's point, this is exactly the argument that was made to the trial judge, correct?
I don't know that I actually, well, I mean,
The war.
the fact is that they were made, but I think you look at in Ray Roland Hubert case. Here's a nephew who became in the last years of the decedent's life, he became the primary person taking care of the uncle. And he pulled out $287,000 out of a joint bank account that, in the end, the court said, well, it didn't matter, because first off, this guy had, he'd been driving him to all of his medical appointments. He'd been taking care of him. He'd been socializing with him. This man's life changed, just like Ralph Christie's life changed in 2014 when all of a sudden this single man, divorced, no children, and no friends, by the way, local. Even the apartment complex noted that the only persons that visited him since 2012 when she was there was the Chetwynd family. I mean, what does that do to somebody? Is that undue influence? I mean, I think that's really, in Hubert, the court said it doesn't matter, the money was going to go to him anyways. In that case, he didn't formalize it. But more critically, I think what we have to say is, what was his mindset on January 30th, 2017? And,
that's part of the picture. To the extent we're talking about questionable acts by your client after the will was changed, in your brief you argue, or at least make an assumption that, you can't look at anything after that date. Why not? Because part of the equation is whether your client exercised the opportunity for undue influence. And to the extent he took out a very large loan and didn't start paying it back until much later, why isn't that perfectly valid evidence?
fair enough. But if that's perfectly valid evidence, so is the care that this man provided to Ralph Christie, keeping him out of a nursing home, keeping him in his own home, in his own bed. The testimony of Sorka, O'Brien, Lydia, all part of the record, that every medical professional that had an opportunity to see Ralph Christie could only say, just like Dr. Mushadi said in August of 2016, Ralph came in with his best friend, Chris Chetwynd. That's the observation. And you talk about undue influence and that it's done in secret, well, then there's got to be something that shows in the decedent that he's doing something that he doesn't want to do. In Moretti, he was hiding under his covers. In Moretti, they refused to allow family members to visit. Exactly the opposite happened here. Just a couple of months before the will was executed, one of the niece came out from out west, and did Mr. Chetwynd interfere and keep her from seeing him, isolate Ralph from her? Absolutely not. He gave them all the time that they wanted to have together, and what was Michelle's report afterwards? Just a couple of months before he signed that will, he was happy and he was doing well. Somebody, somehow, with the medical care that he was having round the clock starting in early January, think about what the professionals at South Shore Hospital and at the Bostonian saw. One of the witnesses to the will, Sam Corey, he testified that he didn't see anything wrong on that day. And not only that, but Ralph was funny. He was always ready to tell a story, and he was happy, especially when Chris Chetwynd came in to see him. That's not the evidence that warrants a finding of undue influence. Somewhere, somehow, that smoking gun had to be there, and it's not. The fact that this mechanic who worked 6 days a week and taking care of his family at the same time he's trying to help this fella out, ends up borrowing some money for him, or takes on a car that sat for 9 months in a parking lot because he was driving him to his own doctor's appointments with his own car until he crashed his own car. He's not a rocket scientist. He was a mechanic. He did the best he could. When it comes to taking care of getting child care, or especially with seniors, trying to take care of a senior in your home, it's all hands on deck. You just got to do the best you can. And that, I think, is what the evidence showed, that he did the best he could. In January...
Your time is up, so you're going to have to rest on your brief for the rest of your arguments.
Thank you, Your Honor.
Thank you.
Good morning, Your Honours. If I may please the Court. Emma Funnell on behalf of the appellee, Donna Medore. As my brother counsel tries to represent to this Court, he submits that there are two issues.
I'm going to ask you to please just step a little bit closer to the podium and use the microphone. Thank you.
My brother counsel submits to this Court that there are two issues that are key in this appeal. I would submit, and following off of Justice Milkey's questions, in this case, whether or not there is a burden shift or an error of the trial court, and I'll submit to you that there isn't and address that in a second. But what we have here is 214 thorough and detailed findings of a trial court. And what the trial judge did is she meticulously analyzed undue influence and the potential elements and points that may give credit to a finding of undue influence. And the way that she did that was in a manner whether or not the burden was on Chetwynd or whether or not the burden was on Donna Medore. There is sufficient findings in the 214 findings to find a finding of undue influence irrespective of the burden. Now, with respect to whether or not the court erred in the shifting of the burden, I would submit to this Court that there is no error in that shifting. It is well established that when a fiduciary participates in and benefits in a transaction, that burden shifts to the fiduciary. And the first step required, and in fact undertaken by the trial court in this matter, was to determine whether Chetwynd acted as a fiduciary to Ralph Christie. The burden wasn't shifted by this judge, and the record will reflect it, until the 6th day of trial, and following evidence from Chetwynd himself. What the judge found, and there is clearly no error in her findings, that Chetwynd had a fiduciary relationship with Christie and had in fact acted in such capacity.
And what facts are you referring to specifically?
So, Your Honour, the number of findings that were found prior to the execution of the will include that decedent became dependent on petitioner for transportation. He drove him to medical...
I'm talking specifically about when he became a fiduciary.
So, there's two ways to look at the fiduciary, as Your Honour is aware. Finding of fiduciary as a matter of law and a finding as a matter of fact. The record is replete of facts that would warrant a finding of a fiduciary as a matter of fact, as well as a finding of a matter of fiduciary as a matter of law. On February 24th, 2016, Chetwynd was appointed as power of attorney for Christie. I would submit, and there is case law well establishing the point, that as of that date, he became, as a matter of law, a fiduciary for Christie. In addition, whether or not a finding...
Excuse me, does that law address the springing issue?
Yes, Your Honour, it does. So I would specifically refer to the cases of Gagnon versus Coombs and Rempelikis versus Russell. And what those cases establish is that as soon as you become appointed pursuant to a power of attorney, whether or not that instrument is subsequently revoked, used, or in fact valid at that time. And the rationale behind that, Your Honour, is because fiduciary relationship occurs when one reposes trust and confidence in another's judgment and advice. And in the naming of an individual in an instrument such as a power of attorney or a healthcare proxy, which was also present in this case here prior to the execution of the will in November of 2015, the naming of an individual demonstrates the amount of trust and confidence that one reposes in another's judgment and advice. In addition, the record clearly establishes that Chetwynd had access to Christie's finances. Prior to the execution of the will, he was writing checks for Christie. He was able to override Christie's free agency and mind in convincing him and manipulating him to enter into contracts with respect to brand new fire red Dodge Challengers, despite the fact that Christie, aged 86, had lost his driver's license. And what Chetwynd was able to do was convince Christie, who was enfeebled and of weakened mind, to enter into a contract which in essence gifts a brand new car, which I think had approximately 200 miles on, gift it to himself while Christie remained solely responsible for the expenses of that. And again, and I think what is key here, is Christie didn't have independent counsel. And I think this is key when we look at this case, because whether or not the burden was correctly shifted or not, the findings unequivocally establish, and the court found correctly, there is no clear error in a finding that Christie had no independent counsel. What you had here is a pattern of Chetwynd overriding Christie's true intent. You have him contacting an attorney that he knows back in spring of 2015 with respect to the car contract in which Chetwynd obtains title to the car. There was uncontested evidence that that attorney did not go over the terms of that agreement with Christie himself. Why is that? Because Christie depended and was reliant upon the advice and judgment of Chetwynd himself. In addition, on January 28, 2016, it was Chetwynd, on his own initiative, who called McWilliams, the attorney, his friend, the attorney that he worked with the school committee. There was testimony and evidence and a finding that Christie had been to McWilliams's house, knew her husband. He didn't contact Chetwynd's prior attorney. And there was a finding that this prior attorney, Attorney Leahy, had been his long-standing attorney since 2002. We're talking a period here of approximately 15 years that this attorney had been Christie's attorney. Chetwynd didn't call that attorney. He deliberately, in an effort to thwart the true intention of Christie, contacted his friend, who happened to be an attorney. The power of attorney was in fact drafted.
There was no allegation that McWilliams was somehow conspired with Chapman to do anything nefarious. Is that right?
Oh, I'm sorry, Judge.
There was no evidence that Attorney McWilliams had conspired or colluded with Chapman to do anything nefarious.
I believe that's accurate, Judge, and I don't believe that there needs to be a finding that she conspired or colluded with Chetwynd. What there needs to be a finding of is that Christie did not have independent counsel. And when you look at the record here and the findings, there is no diligent counsel being provided here to Christie.
But there's also no finding that McWilliams was not a diligent and independent counsel.
Well, what you had here, Judge, is a finding that she was sending instruments directly to Chetwynd, not to Christie. You were finding that the initial contact with McWilliams with respect to the will was not by Christie himself. The estate plan was not initiated by Christie. In fact, the findings demonstrate that it was Chetwynd himself, the very fiduciary that was to benefit from this will, who initiated the contact with Attorney McWilliams. It was Chetwynd who arranged for the checkbook to be brought to McWilliams. It was
at her request.
at McWilliams's request.
Correct.
And that's because, Judge, the communications with respect to this estate plan were taking place between Chetwynd and McWilliams.
But doesn't this argument diminish the role that McWilliams played in this case in terms of the fact that without any finding that she was in any way acted improperly, how can we ignore your brother's argument that she was in fact independent counsel?
Well, Judge, I think when you're analyzing undue influence, you're looking at whether or not there is a combination of an unnatural and questionable testamentary provision, which I would submit that the findings strongly support, accompanied by questionable conditions. And when it comes to McWilliams, unlike other cases where it was found that there is no undue influence present, Chetwynd is involved at every instrumental part of this execution of the will. He is present and instrumental prior to the execution of the will. He is present at the facility on the very day that this will is executed. The will isn't emailed to Christie. The will wasn't provided to Christie. Who is the individual that the will was provided to? Chetwynd, at all instrumental times, Judge. And I think that that is the necessary finding when you're looking at whether or not the testator had independent counsel. And I would submit that there is an abundance of findings by this court that demonstrate that he did not have the benefit of independent counsel. She was Chetwynd's friend. They knew personally, and in fact, after the will was executed, Chetwynd was providing recommendations to her for her admission to the New Hampshire bar. Their relationship continues, and when you're looking at the findings of this court, the court found that the findings demonstrated that Chetwynd had an nefarious intention when dealing with Mr. Christie. And that's because he was manipulating.
I still question whether or not you're really asking this court to actually make its own finding with respect to Attorney McWilliams, that the judge did not find.
I'm not judge. The trial judge found explicitly that Christie did not have the benefit of independent counsel. She made that finding based on the credibility and the weight that she gave to the witnesses in this trial. And so I am not asking the court to substitute its own judgment for that. That judgment and that finding is clear in the record. It is clear in her judgment, and there is no clear error that would warrant this court to find any error with respect to that finding of the court. And I would submit also that the findings, the 214...
Your time is up as well. I'm also going to have to rest on your brief for the remainder of your arguments.
Judge, if... I'm sorry.
Oh, I apologize.
Did I take all 15 minutes?
Were you splitting time here? I apologize. Is that correct?
If it's okay with the court, Attorney Minchoff doesn't mind waiving her remaining time if it's acceptable to the court for me to conclude the argument.
I have to apologize. Okay. No. Is that all right with you?
Absolutely.
Okay. All right. Then you still
Thank you.
have 3 minutes.
I only had 12 minutes, at least on my clock when I spoke.
I don't believe so. I think you had your full 15 minutes. Is that correct?
I saw 12, but maybe it was different up there.
Well, I can't say that I was watching your time the entire time, but I was following our system with the lights, and so all right. Well, let's just start with finishing up with this. All right. So now you have an extra 3 minutes. I was cutting you off to be fair because I cut you off, so I was cutting you off at the same time. So you can have your time has been ceded back to you for your 3 minutes. Let's have you finish your argument, and then we'll address your issue following that. All right? Okay.
Thank you, Judge. So I believe contained in the rationale of this court's judgment is the very clear statement that Christie did not have the benefit of independent counsel. And Judge, I think it's important when you're looking at the cases which support independent counsel. And by way of example, in re Estate of Urban, and I believe that's a case cited to by my brother counsel, the advice of independent counsel is ineffective when the fiduciary is an intruder into the relationship between the attorney and the testator and engaged in acts which subvert the independence of independent representation. And the findings here that it was at all times Chetwynd who initiated, and I would specifically refer to Judge finding number 122. Chetwynd was the one who told McWilliams that Christie wanted to leave him something. He was the one that specifically discussed the will, not just the will in general, but the dispositive provisions of the will. And so the record is replete, Judge, with findings that Christie did not have independent counsel, and I do not believe that there is any clear error that this court can find to justify finding that the court erred in finding undue influence. And that's notwithstanding, and I come back to my very first point, the judgment in this case was so detailed and thorough that whether or not this court finds that there is an error in the shifting of the burden, and I would submit that there is not, whether or not there is in fact an error, the record here warrants a finding and justifies a finding of undue influence. And I would submit on that basis that the judgment is affirmed. And unless the court has any further questions
No, thank you.
of me. Thank you, Judge.
As it turns out, counsel, it looks as if you did have your full 15 minutes because although the clock initially said 12, the clerk changed it to 15 so you could finish up, having realized that there was a difference. You did see 12, and we looked into it, and I would have given you an extra couple of minutes to make sure, but so we cleared that up. And of course, as you both know, we have your briefs. All arguments in your brief are not waived, even though if you didn't touch upon them. And so we will, be reviewing the briefs very, very carefully as well. All right? Okay.
Thank you, Judge.
Thank you. The third case on our list today is 2022-0855. M.R. number 22860 versus the Sex Offender Registry Board. Remind counsel that in this case also is impounded, and so please don't use any parties' names.
May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant, M.R. I'll also refer to him as Doe at some points, I'm sure. So I'm here today requesting that this court find that my client poses no risk of reoffending and he should not be required to register. As you'll see in my brief, he doesn't pose a current risk to reoffend or danger to the community. He committed his sole sex offense in 1995. It was a horrific offense, I will say that, but it was committed in 1995, which is close to 30 years ago. He's been free
And much of that time, he was either incarcerated or in the hospital.
So in 2007 was when he was released from incarceration, and so he hasn't reoffended since 2007, and that's, again, that's a long time ago. During that time, he has been like institutionalized here and there, and he has been in group homes, but for the bulk majority of that time, from 2007 until now, he has been in the community or in a group home, and he has not reoffended. He committed his sole sex offense when he was 18 years old, and at the time of the sex offender hearing, he was 44 years old. So that's another factor that this court and the hearing examiner looked at. And also, he was involved in sex offender treatment while he was incarcerated and when he was released. When he was released, he was involved with, I believe the name of the place was Gandara in 2007. There wasn't a ton of information in the files regarding exactly his progress, but he was involved in sex offender treatment.
Counsel, could I just ask one question? You mentioned his sole sex offense took place when he was 18 years old. Were there not two sex offenses in that same year?
He was convicted of multiple
Yeah, okay.
during the same time. They were both in 2005. I'm sorry, 1995, and he was, I think he went to trial for both of them together as well, so, or during the same time. And during the time of the hearing, he was in a group home, and the hearing examiner did give Factor 33 credit because of that. He was involved in a group home. He had a case manager involved with him, and also he had just a support of a case manager and those people that were involved with him at the group home.
So can I just ask one question? As
Yeah.
far as your argument about the arbitrary and capricious nature of the level 2 determination, the way I understand your brief, you're basically agreeing that the factors were applied, that the correct factors were applied, or that the factors were applicable that the examiner used, and you don't have a tremendously large fight about how those things were weighed.
I would say with the absence, yes. So I would say that the majority of the factors were applied correctly, but that there was all these other things involved with this case, which is, again, his sole sex offense was in 1995, and he was 18 years old, and he was 44 years old, the classification hearing. It's been over 30 years, and he has not reoffended. So there's that part of it, but then there's also the expert. His attorney had applied for funds for an expert, and the hearing examiner had denied it. As you see in the record, my client...
But that's a separate issue.
That's a separate issue, but that is a separate issue. But I believe that's actually my strongest issue, and I know in the brief I put the other issue first, but this is my strongest.
Can I just interrupt? How do you address the perspective that, given the particularly horrific nature of one of the sex offenses here, from one perspective, your client won. He was a level 3, and the hearing examiner, partly because of the very factors you're talking about, downgraded it to a level 2.
Well, I would say under the facts of this case, again, it's been almost 30 years since he committed his sole sex offense, and that time alone, I think, should be enough for a hearing examiner to find that he doesn't pose any risk. And if this court were to find that he does pose a risk, I think level 2 is even too high for him. Again, it's been multiple decades since he committed his sole sex offense. He was 18 years old at the time, 44 years old at the time of the classification hearing. So that's one of my arguments. The other argument, as I indicated, was that the hearing examiner should have allowed my client's attorney funds to hire an expert to test, interview my client and provide any tests that he felt was necessary and have, file a report.
In a situation where a sex offender suffers from serious mental illness, and that is certainly well established here, the argument below for the expert funding was that we need an expert to talk about, if he is being treated and is making progress, what's his risk? How does the mental illness play into that equation? Was there any evidence, or I should say, what evidence was there in the record that he was undergoing treatment and/or that he might age out of some of the mental illness? Because without that, isn't it irrelevant whether he's mentally ill or not?
I'll just say that when he committed his sex offense, he wasn't diagnosed with anything at that point. He was 18 years old, and he wasn't being treated for anything at that point. There is evidence in the record, specifically in the motion that the attorney filed, indicating that first of all, that he had those diagnoses and that he was being treated with medication. And there was also an affidavit that was attached to the motion from, let me see if I could find it here. His guardian, Rogers Monitor, submitted an affidavit indicating that my client was being treated with antipsychotic medication. And then there was another affidavit that was attached to the motion, and that was one from the DMH case manager. And the DMH case manager had been assigned, I believe, 2011, I believe. And during that time that he had worked with my client, he indicated that he found no problematic or sexual offending behavior. I would assert that there is, if you read the application, the motion, there is a connection between Him being diagnosed, first of all, with all those mental health issues, mental illnesses, and also being treated, that because of his treatment, he has not exhibited any more problematic or sexual offending behavior. So, given this, and given his history of mental health issues, and the fact that he's being treated, and that my client's attorney was able to get an expert to evaluate him and to testify at a sex offender hearing, the hearing examiner should have allowed my client's motion for expert funds.
So the hearing examiner should have interpreted the motion as seeking an evaluation based on changed circumstances between the time of the initial conviction and the time of the classification hearing when your client was 44 years old.
Exactly, because
But that's not what the motion said, right?
So he was not, so there were two affidavits again that were attached to the motion. So I agree that the attorney could have made it a little bit clearer and made the connections, written the connections in her motion, but everything's there in the motion. There's the affidavits that were attached to the motion. And so I don't think there's like magic words that she should have placed in the motion in order for the hearing examiner to have allowed it. I think if you read the motion in its totality, it's clear, at least to me, that that's what she was seeking. I actually handle SORB hearings, and a lot of my motions are actually written this way. I'm going to go back and change some of it just to make sure that it's even clearer. But I think if you see the entire motion and the affidavits that were attached, I think it's clear that that's what she was asking for. Funds to hire this expert so that the expert could evaluate my client, or her client at the point, and see what impact, if any, his treatment for the mental health issues that he was diagnosed with has on his risk of reoffending. It is entirely possible that after being evaluated that the expert could have found that doesn't impact it at all. And that's actually happened to me once. But that's possible, but the hearing examiner should have at least allowed the funds for the motion and then gone from there. I think that would have been a clear picture in terms of the risk of reoffending that my client poses, especially given how, such a long time ago that it happened. He was 18, very young, and 44 at the time of the hearing, so.
But that age difference, I hope I'm not beating a dead horse, but the age difference is a different thing than your client's treatment.
No,
correct?
absolutely.
And again,
Yes,
that wasn't the basis of the motion
absolutely,
either.
absolutely. You said so one of the risk mitigating factors would be applied because of the age difference. But yes, they're two separate issues.
So if the question is, for us, is whether there was an error or an abuse of discretion in the way that the hearing examiner ruled, the hearing examiner was entitled, would you agree, to rely on what the motion actually said?
Yes, but I would say in the totality of the circumstances with the attached affidavits, that is really what the motion said. Maybe she should have changed some of the language within the motion itself, maybe, but I do believe that that is what she requested if you read the entire motion and the affidavits that were attached. And if there's no further questions, I'll rely on my brief. Thank you so much.
Seeing none, thank you very much for your argument.
If it pleases the court, David Chennai for the board. I think the one sentence in the guardian's affidavit in the motion for expert funds covers both issues in this case. When he said that, when that guardian said that even with the medications themselves do not improve this individual's competency. It's the instability of this individual.
Isn't competency different from the risk he presents?
Well, I think
he was found incompetent to be tried way back when, so there are some competency issues, but here is, if we do something to treat the mental illness, then maybe that'll affect his risk.
I think what that statement is saying is that the medications aren't reducing his risk. The medications aren't helping. They're not making him more competent. And I think what the hearing examiner, I think, did a good job of focusing on is the fact that with the positive he has, there's still that level of instability, that this individual, we don't know how much access he has to the community. Most of the time, he's been in group homes or hospitalized during his offense-free time.
But can we stay focused on the expert issue,
Sure.
first of all? And I read the briefs before I turn to the record. And having read especially your brief, I expected to see a much thinner request for funds than is actually there. And I'm looking at it here, and there are references to 2 or 3 different studies that talk about the relationship of mental illness and recidivism, and how when someone is mentally ill, there's a negative correlation, et cetera. And there's the sentence in the motion that only an expert who examines the petitioner would be able to assess the risk the petitioner poses, if any, once he's been treated for his mental illness. Now, if it were definitively established, or there was no proof of any treatment, I would agree with you, but wasn't there enough here in this record for his treatment while incarcerated, his many hospitalizations, his taking antipsychotic drugs, to think that it's possible he could be making some progress, not on the competency issue, but in terms of his ability to control himself?
I think you have to look at DOE 89230. In that case, the individual had been treated and showed that the treatment had been beneficial. All we have here is an individual who's got a diagnosis, has had some kind of treatment, and again, it doesn't talk about what benefits he's had from that treatment and whether those benefits may impact his risk.
Don't we need an expert to say that?
Well, but I think again, in DOE 89230, the point is it's up to the offender to establish that nexus, that what he's doing right now is having a positive impact, and an expert should be able to talk about that. There's no evidence that the treatment has actually been successful for this individual. In fact, the evidence is more that he hasn't really improved, at least that's what the documents indicate, that he hasn't really had much improvement since his treatments going back to 2011, and that because of that, he's been monitored pretty closely during that time.
That may be the case, but the reality is he still has not reoffended. So why isn't the combination of not reoffending, the fact that he has documented severe mental illness, and we know he's undergoing some treatment, why isn't that enough to get the foot in the door to get an expert to look at these issues?
Well, again, I think you got to rely on DOE 89230, which is very specific, that they have to show the nexus. Besides having a diagnosis, they need to show a nexus between that diagnosis and a lowering or an impact that would lower the risk or danger. And that nexus wasn't here. They were asking for expert funds to make that nexus. And again, these cases aren't supposed to be like SDP cases based on expert evidence. It's been very clear since 2006 with DOE 10216, expert evidence is not required in these cases. And DOE 89230 stretches that out a little more and says that these are the standards you have to make to get that expert, and it wasn't met here. And I think then you look at the board creating the regulation 803 1.164, which again takes the DOE 89230 and kind of codifies it. And again, the impact or the import of it is that the nexus has to be established, diagnosis and nexus, and that nexus is showing that because of this individual's current circumstances, there's evidence that there may be a reduction in his risk, and therefore an expert would have to be appointed to help the hearing examiner with that issue. The nexus wasn't established here, and that's the board's position on the expert evidence. And I think the hearing examiner did a really good job moving on to the analysis portion. I think the hearing examiner did a really good job of trying to balance out the years that have gone by with this individual's current instability and the possibility that he may have contact with the private community with his background, which includes violent behavior that he exhibited throughout his incarceration, and just the heinous nature of the sex offending behaviors. So I think the hearing examiner, looking at it, I think made a good judgment in saying, we'll lower him to a level 2 and see where we're at. In 3 years, it may be lower. Something may happen in between, we don't know. But at the same time, I don't see at this point that the hearing examiner could have dropped him to a level 1 just because of those factors.
Well, let me ask this. To what extent are you making a no prejudice argument, namely, even if the hearing examiner erred in not giving funding for an expert, there's no way on this record he's going to get down to a level 1. There's no way to imagine even supplemented by the expert's advice.
Well, I mean, you can argue that. I think it's
I'm not arguing anything.
Yeah.
I'm asking.
I'm actually having you argue it for me, but no, I think, it's kind of speculative in the sense that my sense is, with the individual circumstances, that an expert wasn't going to be helpful. It wasn't going to, and I don't think an expert was going to look at this and say he poses no risk or poses a very low risk. But again, that's speculative because the evidence that we have in front of us does not indicate that an expert would have been able to say all of these positives add up to no risk. I just don't see that happening in this case. Again, the medications don't seem to have improved this individual's situation greatly in the since 2011. Based on the hospitalizations, based on the group home situations, they have been trying to keep him out of the community, and there's a reason for that. And again, I think it goes back to this individual's stability. I mean, it's heartbreaking that an individual suffers from these issues. As a parent, I would hate to see this for my child, but the reality is it still is a risk and danger situation should he have access to the community at this point.
Do you accept that the mental illness may well have played a role in his original sex offenses?
I would hazard to guess yes, but at the same time, we haven't seen improvement in his mental health
No,
situation.
I understand
Yeah.
that. I'm just...
But I do believe that that was probably part of it. I mean, I don't know the whole history, his whole history, but I'm assuming that he was suffering from these issues then. So I think you can make the reasonable inference that his mental health issues did have an impact on his sex offending behavior. Again, that goes to the future where would his current mental health status, based on the evidence that we have, prevent him from doing it again? And I think that's what the hearing examiner wrestled with. So unless there's no further questions, I'd be more than happy to rest on my brief.
I see no questions. Thank you
Thank
both
you.
very much. Move on to our next case now, which is number 2023-0257, Notre Dame Training School versus the Town of Tyngsborough and others. Okay.
May I approach, Your Honor?
Yes, you may.
Okay, thank you.
Good morning.
Good morning, Your Honors. My name is Christopher Petrini. I am, may it please the court, counsel to the defendant, or the defendant here, the Tyngsborough Sewer Commission. With me is my co-counsel, Heather White. Your Honors, what is at issue here is a betterment that was assessed by the Tyngsborough Sewer Commission pursuant to Mass General laws, which calculated the betterment for this particular property, which is the Notre Dame Academy, a Catholic school, the same exact way as it assessed the betterment for 172 other property owners that were subject to the betterment, which is to consider future use as well as present use as is permitted by and required under state law. Now, the Superior Court granted summary judgment to Notre Dame Academy on the grounds that Notre Dame's betterment should only be based on current use, and that's inconsistent with the statutory regime of Chapters 80, Section 1, Chapters 83, Section 15 and 16.
Is the way that the betterment was assessed here inconsistent with what the bylaws require?
We don't think so, Your Honor, because the bylaw in question, I think you're alluding to Section 4.2.2,
Yeah.
which talks about a process here when there are two years of water records available. And basically, the summary judgment record establishes that the water records were considered on two separate occasions here. First of all, Woodard and Curran, which was an engineering firm that was hired by the Tyngsborough Sewer Commission after the betterment was approved by town meeting, presented calculations to the Tyngsborough Sewer Commission using all three methods of establishing the betterment, one being CWMP, which is the version that was used, one being based on the actual water usage records, and the third being there was a third method that will come to me in a moment, apologies, but they were all considered, and during that part of that process, and this is on the record appendix pages 209 to 217, that analysis included evaluation of those properties that did have water records available. And basically, based on the recommendation of the engineer, since so many of the properties concerned vacant land, that it was determined that it would be the most fair and equitable way for all parties.
Counsel, in your brief, you make an excellent case for why the comprehensive system the town came up with is fair, equitable, rational, et cetera. The problem is you're still stuck with the wording of the regulation, which seems, speaking at least only for myself at the moment, fairly clear that where there's been metered use of non-residential property, you start with the last 2 years of metered use as the presumptive amount you're supposed to use. There is an out. If the commission determines that the 2 years is unrepresentative, but as best I can tell, the commission disavowed relying on that out below. Is that a fair summary?
I don't think it's entirely a fair summary. You do summarize an aspect of the regulations correctly, but we do provide at summary judgment that the water records were provided to the commission at the time that the methodology was accepted. And yes, there was not a vote, Your Honor, a specific vote per se of the commission, but by accepting the betterment methodology of the comprehensive waste management plan assessment, that constituted a decision. The regulation in question uses the word deems. And it does, and if I may read it, Your Honor, it does say, if less than 2 years of metered water consumption records are available, which is not the case here, they were available. This is page 232 of the appendix. It's been reproduced several times. You probably have it 5 times in the record. But in any event, but it does say, if less than 2 years of metered water consumption records are available, they were available, or if the commission deems that the water records are not representative of the potential usage, the calculation shall be based on Title V or CWMP. And it's our position that, and this is in pages 211 to 217 of the record appendix, deems doesn't specifically require a finding or a vote. It was basically, the records were presented, the methodologies were presented to the commission, and they did consider, it's undisputed that the commission did consider the actual water records and followed the advice of the engineer in determining, you know what, the water records are unrepresentative because they simply did not account for future use. And so what's happening here is you have 172 other parcel owners that are being paid for considering future use under the CWMP method, and then you have this particular school just based on present use. And then there was a second time, Your Honor, again, where this...
Can I interrupt you?
Sure.
I'm not really sure I understand if you've
Sure.
answered Justice Milkey's question, which is, there's no argument that those 2 years were unrepresentative, right? In other words, are you saying just because you can infer that was the case because it was the billings and the amount of water usage was presented, that we're going to infer that was
Yeah,
the finding, that was, excuse me, that was your position?
That's right, that the language talks about being deemed unrepresentative, and our position is that by the engineer providing those water records to the commission when they selected the CWMP method, and the commission selecting the CWMP.
Your position is that, your point is that was not abandoned, that was you, in
Correct.
fact, that decision was made?
Right, exactly, that
By inference, so to speak.
We believe it was sufficient under the regulations, again, construing the regulations as a whole, and I know Your Honors are familiar with the case law about it being a very relaxed review here, and particularly where they're objecting to a particular application, and if this stands, then the 172 unit owners or other properties are basically going to fund the excess sewer costs that are not being paid by this particular property owner because they only considered current use, and I see Justice Milkey has a question, so I better pause.
Yeah, in terms of your response to
Yes.
Judge Vuono, I was trying to find it, but I was unable in my quick fingers. There is an interrogatory answer in which the commission appears to have admitted that it did not determine that the 2 years of data was unrepresentative. So my question is, assuming I'm correct in what the record says, how do you deal with that in terms of your argument that it was implicit that you found this?
Yeah, I think you're alluding to, yes, Your Honor, I think you're alluding to page 115 of the record appendix. I'll direct you to that interrogatory. And it does acknowledge that it did not specifically make any determination relative to the school. But what we're saying is that the type of vote or the type of specificity here is not required as a reasonable interpretation of the regulations, because there are plenty other, and we point this out in our briefs, Your Honor, there's 90 other instances in this regulation where the word shall is used, including the need to account for future use. And so, and we cite this in our reply brief, but you have the Boston College Quinn Bill case, Adams v. Boston, that talks about how you analogize or compare, how you rationalize different shalls, because arguably this section of shall is inconsistent with the other sections of shall, requiring that future use be considered. Future use is not being paid for right now by the school, and that is that you look to the overall statutory scheme, and there's abundant case law which basically says that a future use, this is Chapter 83, Section 15, there's numerous cases we cite, W.R. Grace and others in the brief that say it has to be proportional and it has to consider future use. By accepting these 2 years of water usage, you're basically taking a snapshot in time of this school, and we have evidence in the summary judgment record that their use was a lot higher in prior years than this 2 years in question. In a perfect world, I have to acknowledge it would have been better if they had made a specific finding or vote, but I don't think the regulations or the law require that level of exactitude that the Superior Court did at summary judgment. And
Could I just interrupt you for
Sure.
1 minute? And I'm sorry to do
Problem.
it, but with respect to the issue about proportionality.
Yes.
It seems to me that the requirement of proportionality was addressed by the regulations that were implemented 4.2.2 as part of that, if I have the right number of twos there, I think I might be short one. That was the way the town determined it was going to decide what was proportional. And the fact that ultimately an engineer or others decided that they didn't agree that that was proportional is the reason why a different method was used. But I'm not sure that I understand the proportionality argument where it seems as though that determination was already made by the regulation, by the implementation of the regulations or adoption of the regulations.
And I do understand your point, Your Honor, and I guess my response would be that the outcome here is that you have a situation where you have $9.2 million of costs of this betterment that are being shared by 172 other property owners, and this particular property owner is not paying a proportional assessment because of their fair share. Now, I understand your point about that there was a procedure set forth in the regulation, that we're saying the actual water records were looked at twice, once at the time of, establishing the actual methodology used in 2017, and then again, by the way, when the betterment came up for review, the actual water records. And there's nothing in this regulation, that section, that 4.2.2, that specifically says when and where and how that language must be used. And the case law is deferential. This would be a different case if Notre Dame Academy were being treated differently, worse than every other property owner. But in fact, they're being treated better because they're not paying for future use. They're simply paying for current use. And that is a big factor in the case law. The 96 LLC case talks about how you have to look at whether there's been somebody who's actually been discriminated against. There's no discrimination here. Notre Dame is being treated exactly the same as everybody else. It's the other property owners subject to the betterment that are being treated properly. So I'm not sure I answered your question 100%, but I'm happy to answer any follow-up on that.
No, that's helpful, but isn't the avenue for addressing that inequity a challenge to the regulations and not simply implementing a different method?
Well, we would say, while it might have been inartful, we did comply with the regulations by submitting those particular water records at the time that the CWMP method was determined, because that was found to be unrepresentative, because there was large swaths of unused land in town that had to be accounted for, and the engineers and the commission were also concerned about subjective interpretations. When is it going to be acceptable? When is prior water use representative or not representative? So we believe in terms of the deferential standard under the case law, which says any reasonable basis in applying these regulations or interpreting the regulations should be acceptable, particularly whereas here there's been no harm, because again, it's been the other, in our view, the other property owners that have been adversely affected, because these costs don't go away. They're basically shunted off to the other property owners.
I'm having a hard time accepting your premise that the commission implicitly found the two-year data to be unrepresentative. It appears more they said that it's unfair to use that data, but in terms of whether or not that was a representative look at what the school was doing in terms of its outfall, I'm just having a hard time accepting that premise.
And I respect that, Your Honor. I just would turn your attentions to pages 209 to 217 of the record appendix. We do have uncontested affidavits or affidavits that Notre Dame sought to strike that were denied, so they are part of the record, and they do have to be considered in the light most favorable to the non-moving party here, and or the party against whom summary judgment was awarded. And the page 216, the engineer does say that in his view, this does not represent a proportionate share of the betterment, and he does go on to say on pages 214 and 215 was basically, he writes at the bottom of page, this is Jack Troidel, one of the engineers from Woodard and Curran, on the bottom of page 214, the full parcel build-out method, hold on a second here. And yeah, basically, he says on the top of page 215 that he emailed these spreadsheets, which presented a parcel-by-parcel assessment to the commission on July 18, 2014, and extensively reviewed them with the commission at several meetings with multiple iterations over a period of several months.
I have to have a quick question for you. I'm sorry to interrupt your train of thought, but your time is almost up.
Sure.
So you're indicating that all the properties are treated equally, but the majority of those properties, there was no data for the water usage over the past 2 years, correct?
Yes.
Right. So they were treated equally in terms of the fact of the majority of them didn't have that data, so the data wasn't looked at any of them,
right,
despite the fact that the school did have that data.
And I do apologize for interrupting you, Your Honor. You're correct, but there were certain other properties that did have the data, that a decision was made for purposes of fair and equitable treatment for all property owners, that it would be the best approach to follow this consistent method that took subjectivity
So there
out
were other properties that had data for water usage, and that particular information was ignored in those cases. Well, ignored, but not relied upon, so to speak.
I wouldn't use the word ignored. It was considered, and it was determined that they weren't representative.
We'll take out ignore. We're just saying it was determined that you're not going to rely on that information to make your assessment.
They were determined that it was not representative, is what our position would be. Okay.
I've taken you past your time. I'm going to see if there's any other questions.
Thank you, Your Honors, I appreciate
Thank
it.
you.
Members of the panel, and may it please the court, my name is James Radke, and I'm here with my colleague Tom Vangel, and together we represent the FLE, in this case, Notre Dame Training School. I think the questions that were asked early on by Justice Hand and Justice Milkey are dead on, and really go to the key issue in this case, which doesn't the bylaw govern how the developed non-residential property that the school occupies should be treated under these regulations, and it does. The language is very clear that metered properties, properties that are metered for water use, are to be treated in a different manner, and sewer units are to be calculated in a different manner than those that are unmetered. And what is plain, at least in our view, is that that did not occur in this case, that the Commission did not apply the proper calculation, and that we ended up with a betterment assessed on the school that was just about 3 times what it should have been. They calculated 44 sewer units. The proper calculation would have resulted in 15 sewer units. So we would ask that the court affirm the judgment of the Superior Court and find that the school's entitled to an abatement.
So you argued that the town misapplied its regulations, did not adhere to the particular presumptive use of this. And you prevailed on that. Assuming we agree with your argument so far, why isn't the remedy a remand for the Commission to do it right in accordance with the regulations? I represented a lot of agencies in a past life, and typically they get 2 bites at the apple. If they did not adhere to the regulations, why shouldn't we send it back?
Well, there is no dispute about what the calculation would have been had they done it right.
But that makes it presumptive. It doesn't make it definitive. And if they were to determine that it was not representative, for whatever reason, they could do something else, right? Even under your interpretation.
Well, in our interpretation, Your Honor, they would have needed to make that determination when they calculated the betterment. This sort of after the fact review and the opportunity to do it again, second bite at the apple. We would argue that's not appropriate, that it does need to take place at the time the betterment was calculated. On that point, I would refer the court to the case of Myers versus the town of Nantucket. This is a decision that Justice Vuono authored in 2010, a little bit of a different context, but in that case, a homeowner on Nantucket had done his own plumbing work, and there was a building inspector who issued a fine and then also had issued an order to take out the plumbing. And what the court found, this court, was that there needed to be, at the time that order issued, there needed to be a finding that there was unskilled workmanship that had gone into that plumbing work. And so there was no finding made at that time. And so that order could not stand, the removal order of the plumbing. So I think it's a different context, but it's a similar issue, but in terms of the timing. I want to talk about the concept that was raised about current use versus future use and potential use. The Superior Court did not actually find that, did not actually base its determination on the school's current use. What it found was that the Commission had not followed its regulations. I think what's important to remember is that the water records are a form of evidence of potential use. This is evidence of what, in the prior 2 years, the school has actually used for water in its daily operations. And so that does provide evidence of what the potential is. Unless there's some drastic change, then that does tell you something about what the expected use would be in the future. So it's not the case that the Superior Court made this grievous error and based its finding on, quote, current use. What it did was it used the presumptive evidence that was written into these regulations that water bills are to be used. And it uses, the regulation uses affirmative language. It says 2 years of water records shall be used in the calculation of sewer units for these type of properties that are.
How do you address the Commission's argument that other parts of the regulations also use the word shall? So there's, if you read them all together, there's got to be some give here and there.
Understood. And what I would say is there are other instances of shall, but they don't conflict with each other. And so there is nothing that conflicts with those other areas that require proportionality or a look at potential use doesn't conflict with the shall use water records for the point that I just made, that the water records themselves are evidence of potential use. Now, if the Commission had looked at the evidence and made a finding that they weren't representative for whatever reason, then they had the opportunity.
In a situation where it didn't feel the need to go there because it was relying on this more comprehensive methodology it had developed through its consultant, why shouldn't it go back to the Commission to examine the question in accordance with its regulations of whether or not the 2-year usage was representative?
Well, I'd like to unpack the timing a little bit, because when the engineers were looking at these 3 different methodologies, and they say that they did in fact look at the water records, that was done prior to the enactment of the regulations. So if they had decided that this is the way it should be done, I'm not arguing today that they couldn't have written the regulations that way, but subsequent to their review and recommendations, the town enacted the regulations, and the regulations required that this be done in a certain manner. And so the timing of their review and then the subsequent enactment of the regulations, I think, is very important here. And they were written in a particular way, and they needed to be followed. And you know, the town could have amended its regulations had it determined, because there's a few years there before the betterments were actually calculated. If they had wanted to do this in a different way, they could have amended, and they didn't. And the town has, in fact, since this decision, amended its regulations.
Do you agree with the Commission that if we are to affirm the Superior Court here, the net result is the shortfall has to be borne by all the other property owners?
I don't think that's right. I think it would be borne by the town, because the assessments have already been done. The period to seek abatement from the other property owners has passed. If there's a shortfall, I think that would fall to the town at this point. I'm not entirely sure on that point, but it was the town, in our view, that made the mistake here. And to us, it's not a windfall to the school. It's just the proper calculation under the regulations. What would happen really is that the difference in sewer units between what they calculated for the school and what should have been calculated would come out of the pool. So it would slightly reduce the overall number of sewer units in the project, but it would not have a drastic difference. So our view is it's not a windfall, and we're not being treated better, as the Commission's counsel implied, than anybody else. We're just being treated appropriately how the regulations require. And this is significant to the Notre Dame Training School. I mean, this is an over-assessment of $337,000. And to a nonprofit school, that's real money. And it's very important. And it's 3 times what it should have been. So, you know, we're not asking to be treated better. We don't think that we were treated better, but we are asking that we be treated the way that the regulations require, the plain language of the regulations. And I did want to address Justice Hand's question about proportionality. And I believe what you said is absolutely correct, that the regulations themselves incorporate the uniform unit method, and by doing the conversion of each property to sewer units and then assigning a cost to the sewer units, that is baked into the regulations as they're drafted already. And in the W.R. Grace case that both parties cited, that's 62 Mass Ave Court 462, the court said explicitly, and I'll quote, because the bylaw formula is grounded in flow rates for the conversion of commercial uses into equivalent residential sewer units, it is clear that the costs are calculated in proportion to the benefits conferred. So what this court was saying was that by using the uniform unit method and converting properties to sewer units, you're covering the proportionality requirement that has been required by the cases and the statutes. So that it has been met here. The Adams case that was raised on this, these competing shalls, in the Adams case, this was a case about the way that policemen were paid, and there was a conflict between a statute and a collective bargaining agreement. And so the court tried to come up with, well, how can we square these two shalls? And I would just repeat what I said earlier, that we don't believe the shall in 4.2.2.2, which requires the use of the water records, that we don't believe that conflicts with any other shall. They can all be squared in a way that works here.
Okay.
Unless there are other questions, I would yield the rest of my time.
Okay. Thank you both very much.
Thank you.
Okay, so that case will be taken under advisement as well, and we'll go to our fifth case on the list, 2023-0435, CP 200 State LLC versus CIEE and another. Okay. Ready, counsel, when you are. Good morning.
Good morning, and may it please the court. Jack Woodcock for appellant defendant CIEE. Soon after this case started, the parties entered settlement negotiations. They discussed the amount of the settlement, when it should be paid, and that those two actions would settle the case. No other terms were discussed. On August 25th, 2020, through a series of emails, the parties agreed to a settlement amount, when it should be paid, and that it would resolve the case. Under basic contract law and ample precedent from this court and other Massachusetts court, the parties reached a settlement agreement on August 25th, 2020. 200 states attempt the very next day to demand twice as much money fails.
Well, just before the next day, there was another email exchange late in the evening, right?
Yes, Your Honor.
Okay, and that would be the exchange in which counsel for State Street says that there is no deal at that time.
That there's no deal, that there was a quote-unquote another level of authority. It is worth noting that the amount that was settled, $245,000, was long the demand of 200 State. So they had long demanded this, and then eventually CIEE ceded to that demand, met the 245. 200 states attempt to wriggle out of the deal fail because, for the first reason, that it runs headlong into this court's precedent that if the parties later memorialize a settlement agreement, that doesn't mean that a settlement agreement has not been met. Basic Tech is the leading authority on this, and there Amazon argued exactly what has been argued by 200 State, that the prospect of a future written settlement agreement scuppered the deal. This court rejected that. That same year, this court in Fecto addressed a similar argument, and Fecto is even more on point. There, it was argued that the parties didn't intend to be bound until a written settlement agreement. But the agreement met all issues, just as it is here, and it was the written settlement agreement is a memorialization of terms, not an effort to create new terms, just as it was here.
Can I ask you a question? There was the 7 o'clock, 7:14, whatever, email saying, I would paraphrase it as saying, whoops, I have another layer of approval. The response back, it may have been the next morning, was if we go forward with the hearing, all bets are off. How are we supposed to process that statement? Because it wasn't, we had a deal, you're bound, end of story. It seemed to leave things open. It seemed to acknowledge that things were still open.
To answer Your Honor's question, the parties did agree to postpone the hearing, and that the all bets are off statement merely states that if the hearing goes forward, that would be a material breach of the parties' agreement, and that a material breach excuses the party, non-breaching party, from performance. So that just meets black letter contract law, that if a party breaches the agreement, which CIEE thought at that point that all bets were off because the other party had breached, and it would be up to CIEE to respond.
Well, that is certainly one interpretation. It's not the one that immediately sprang to mind in terms of what the all bets are off meant.
The timing here is important. So it was the parties reached an agreement that day, and then
that evening.
That evening, and as the record notes, it's the next morning. So that's the day of the hearing. And so
there is another exchange that may support your point of view, not that we're in a position to take sides on either at this point, because of course we don't. But at 7:49, I presume that's also still PM, as you or someone on behalf of CIEE says, keep me posted. Our understanding is we accepted your offer. Let's wrap this up, thanks. And then the next morning is the email that Justice Milkey has, in my view, correctly summarized. What's going on here? All bets are going to be off if this hearing goes forward. So what do you say about that comment there? Is that just not relevant to this comment the night before, or does it have any bearing on the comment that comes the following morning?
I think the comments that come the next day are indicative of an agreement that happened the day before. The string ends, your withdrawal comes too late. We accepted your offer, which is immediately after the exchange. So that's on an email at 11:15 a.m. And I think it's important that the email the prior night, the last one, does say there's another layer of approval, but says, and this is from 200 State, my sense is that everything is on the right track. So there's nothing indicating that the deal is falling apart at that point. It's just that, hey, we've got another level of approval to meet here.
And to Justice Vuono's point, the response by your client is, right, we have a deal.
Yes.
Correct?
Yes, it's in the string of emails. Turning to another case, Gorin. Gorin makes the proposition that parties can defer the ability to reach agreement. This court uses a colorful language. It may be commercially useful to allow the parties to hug before they marry. But it's been the law since Gorin, which is a 1987 case, that they have to speak plainly to do so. And so the Gorin notes that the proviso allowing that an agreement is not met until it is written should be stated as such. The purpose of this document is to memorialize certain business points. The parties mutually acknowledge that their agreement is qualified and that they therefore contemplate the drafting and execution of a more detailed agreement. They intend to be bound only by the execution of such an agreement and not by this preliminary document. And that is in great contrast to the document which 200 states says was a conditional offer, which is, we have a deal. We have a deal is very different from, we don't have a deal. We only will have a deal upon execution of a written settlement agreement. A main thrust of 200 states' argument is that there were two conditioned precedents for the settlement agreement to take effect. Assuming these are conditioned precedents, which we address in our brief and do not believe to be the case, but assuming them for the sake of argument, those conditions are that the hearing would be postponed and that the parties would enter into a written settlement agreement. The doctrine of prevention stops 200 state from taking advantage of not following through on the promises it made. 200 state said it would call the court and take down tomorrow hearing. All it had to do was the ministerial task of call the court and take down the hearing. It didn't do that. 200 state agreed to draft a settlement agreement. It didn't do that. The pen was in its hands and it never picked up the pen. 200 state prevented the very conditions from happening and then therefore cannot take advantage of their non-occurrence. And the reason is plain. They want to back out of the deal. They had an about face and demand twice as much money as had been accepted. One final point, 200 state has requested attorney's fees in conjunction with the settlement agreement. This is a collateral matter then to the underlying lease, as the Supreme Judicial Court has already held in an interlocutory appeal. The lease deals with the building. This settlement agreement is wholly separate from the lease which governs the building. No party is entitled to attorney's fees. And if there are no further questions, CIEE yields on its briefs.
Thank you very much.
Members of the panel, may it please the court, my name is Joseph Ruccio and I represent CP 200 State LLC. We respectfully request that this court affirm the lower court's order because there are two unmet conditions precedent to a deal being struck at $245,000. These were conditions precedent to the formation of a contract, so by their very nature, they are material terms.
Oh, okay, so you're referring to the email that came at 3:59 in which it was stated, we have a deal. Provide the parties, one, agree to and execute a written settlement agreement, which I will draft, meaning the person representing your client. And then second, my office will contact the court and take down tomorrow's hearings. Are those the two conditions that you're referring to?
The two conditions that I'm referring to are one, postponement of the attachment hearing, which I would argue is the main condition precedent. We also have the execution of a written settlement agreement.
How is that a condition precedent? It's a condition precedent to their agreeing to the deal, but then you agreed to take the hearing off. So there was an agreement. So,
well, the wording is very important here, I would say to the panel. And one of the themes that's advanced by CIEE is that there's buyer's remorse. I would say that has the story half right. I would say it's remorse here that we're dealing with on the part of CIEE for wording the emails in the way that it did.
Well, let's back up. It seems to me that maybe your client wasn't too happy with settling the case for $245,000 because within 12 hours they're asking for double that amount. So clearly there was that your client was not pleased with the quote-unquote deal that was being discussed the day before. Correct?
That is correct. And the door was opened to renegotiate by virtue of the wording of the hearing email. And that is the email that...
How?
You agreed to take the hearing off, so if the hearing didn't go forward, it's a breach. It's not, oh, we're off the hook because the hearing didn't happen.
Well, Your Honor, I think you have to, and to the panel, I would say, I think you have to look and see whether we have a matching offer and acceptance.
Yeah, I
Okay,
time it at 7:14.
Let's look at the offer. The offer is that $245,000 will be paid within 7 days of an execution of a settlement agreement, and then this assumes tomorrow's hearing is postponed, so no money can be spent. You can take the first cut at that agreement. Response: we have a deal. Provided, one, the parties agreed to and execute a written settlement agreement, which was up to you to do, and you didn't do, but so you agreed to do that, and then you didn't do it. And, quote, my office will contact the court and take down tomorrow's hearing. Didn't do that either.
Yes, that's true, Your Honor, and I think there's good reason for that. First off, you have to look at the predecessor email, the hearing email, where they ask for actual postponement. CIEE had the option to use the wording that was used in the election case, which we have attached to our papers. In that case, a return email was asked for. Here, a return email was not asked for. It said this assumes an event is not occurring. The response was...
And there's an agreement here that the event will not occur. We will take down tomorrow's hearing.
Yes, the response was, we will take it down. It's also important to keep in mind there was a reservation of rights right after that, which says we reserve the right to put the hearing back on if we don't have an executed settlement agreement.
But there was never any discussion about problems with the executed settlement agreement based on the settlement agreement itself. It was just, that was the mechanism used to rationalize the change in the amount, right?
I don't think that that is the only reason that CP 200 could change its amount. I think the primary reason is the fact that CIEE stated very clearly in the initial email, this assumes an event is not happening. It then backed up our impression of what it was saying, which is, no, if there's a hearing, all bets are off. I
have to say you're ignoring something important, which is to the extent that CIEE says, look, there's not going to be a deal if the hearing's not postponed, right? They say that, you can infer that from the email at 340. But your response is, okay, fine, we'll take care of that. We'll postpone the hearing, and I will take the first crack at getting this written settlement agreement done, and then it doesn't do either one. Instead, what you say is, hold your horses. I've got to get another layer of approval before we can have a deal. Two things are taken out of CIEE's hands at that point. You're supposed to be drafting the agreement, and you don't, which is not done, and you're supposed to take the hearing off, which doesn't get done. So how is it that then you can reverse that and say, once the hearing went forward, or the fact that you didn't take it, you weren't going to postpone it at that point in time, all bets are off?
Well, I think it's important to note that the statement that the hearing would be postponed was qualified with a reservation of rights, number one. Number two, it was volunteered. It is not directly responsive to the hearing email. The hearing email says this assumes an event will not happen. In a sense, we have two ships passing in the night.
Well, then you agreed to it, though. Let's say that's even true. Let's just say it's a new material, as the judge concluded, that this was, what was inserted into the negotiations was a new material fact, right? Even if we were to assume that, the response is that you agree to do it. Take the hearing down.
And my response to that would be that's an unenforceable promise, especially when you look at the language. And the language is a qualified promise to not go forward with the hearing. And I would also point out that
How is that? Where's the language that says it's qualified? The only qualification has to do with a written settlement agreement.
there's a reservations of rights in which.
Can you point that out to me?
Sure, it's the very, we're at the appendix page 136, the very final line of the email says, if we cannot work out a written settlement agreement, then my client reserves its right to put the hearing back on at a later date.
Correct, but that didn't even, but that didn't occur. You didn't provide a written settlement agreement to be worked out or not to be worked out.
Well, they did not work out a written settlement agreement. That is true.
Which should have happened in 7 days, didn't have to happen in 12 hours, right?
Well,
everyone agrees there'd be 7 days of it, or the execution would be in 7 days of the settlement agreement.
Your Honor, respectfully, that settlement agreement should have happened, presumed that we had a binding deal at that point in time.
What?
Which in turn.
What material element was missing from the agreement?
There were two material elements. One, a self-imposed condition by CIEE that this hearing not happen. And that is a very material term.
That was agreed to. It wasn't, it may have been self-proposed, but it wasn't self-imposed.
If you look at the language of the emails here, the hearing not going forward was the condition precedent. The hearing not happening, because the consequences of that hearing happening were significant. It not only meant attorney's fees, as is admitted in the text of the email, it also meant that CIEE was facing a real risk that it was going to lose valuable property. If the attachment issued, that was a...
But that's not in the emails.
Which may be why it proposed it and why, and then it was agreed to. I mean, why doesn't the 714 email read, only slightly between the lines, whoops, I thought I had authority to resolve this at 2:45, but I may not. I'll get back to you. Isn't that what it's really communicating?
I think that requires reading into the record information that's not there. I would.
It's admitting that there's another layer of approval.
Which also supports the reason for a settlement agreement. When you have a written settlement agreement and a client has to sign, it's going to make sure that all layers of approval are met. So that written settlement agreement
Is there any dispute that 200 State Street failed to provide a written settlement agreement by the following morning?
A written settlement agreement was not provided. Instead, we had an email with an increased settlement demand.
Okay, but that, in contradiction to the promise that a written settlement agreement, you would, the first crack at it would be taken by you, and then CIA says, understood, we look forward to seeing the draft and closing this out. But the draft never materialized.
Correct. We have the email response instead. And I would also point out that the use of the word deal needs to be kept in context. And that's a point made by the D'Agostino case, which we cite to in our papers. There the word deal was used but was not dispositive. But that's because when you look at the whole picture here, deal is very much, it's very reasonable to interpret that as an affirmation of, okay, you've said that the hearing not going forward is the way we accept the offer. And the response was, okay, I recognize that. I will get to work on a settlement agreement. And as consistent with that statement, CIEE CIEE came back with a new number. If that was agreed to, a settlement agreement probably would have been reached. Another point about
I'm a little confused. CIEE did come back with the number of 245. The new number.
I'm sorry, CP 200 state came back with the increased offer. Had the response to that increased offer been, we have a deal, that would have, I'm assuming, put them on the track to a written settlement agreement.
Why is that different than we had a deal that happened 12 hours earlier?
We have a deal provided that there is a written settlement agreement. And my office reserves the right to put the hearing back on if there is not a written settlement agreement. That's the response.
What's the missing material element?
Again, Your Honor, I think that it needs to be kept in mind that if we can just dismiss the all bets are off email, which preceded the I thought we had a deal email in time, if we can dismiss that, if we can dismiss the language, this assumes tomorrow's hearing is off, then what right does a party have to have its terms enforced as written? I think you get to the result that CIEE wants here when you use a come on, we all know how things work approach. But when you actually stick closely to the language used here, we have an offer that is an event not occurring. We have a response, which is, I promise to take it off. That's not responsive. We have two.
How is that not responsive? It satisfied the condition that they asked for.
In the election case, Your Honor, the email that offer there said, you may accept my offer by reply email. That was an option that's an option attorneys often use, as indicated by that case. That's an option that CIEE could have used here. The fact that it didn't say that postponement of the hearing is immaterial, and that's what the D'Agostino case also stands for, that put in a disclaimer, if you're adding additional terms and they can be conceived as material, put in a disclaimer. CIEE avoided many chances to clearly state what it claims now is its case.
Well, or you could say the same really about your client. What your client could have said is, I need approval for this agreement, and I'll get back to you. And at that point in time, I'll either have a written settlement agreement or I won't, or I'll tell you at that point in time whether or not this hearing will go forward or not. Because there was really no reason for that hearing to go forward if there was an agreement, right? I mean, there's no question that if there had been a signed settlement agreement, you wouldn't have walked into court looking for an attachment. The judge would have said, what are you doing here, right?
Correct.
Okay, so as far as CIEE is concerned, at this point in time in the evening, as they say, which actually preceded the all bets are off email, our understanding is we accepted your offer.
I am looking at an email at 11:15 a.m. on the 26th where the CIEE's counsel says your withdrawal of the offer comes too late. We already have accepted your prior offer.
Go back one to RA 135, I think is where we're looking. It's the top of the page at 7:49 p.m.
Okay, well, that, I think the language of that email really shows what happened in this exchange. He thought that he accepted the offer when he clearly proposed a counteroffer. I think this is a situation where the court can say, this was a mess. No one, if you look at the language, which we are bound to do, no one spoke correctly, responsively, and therefore
Well, I will say it's a little sloppy. I think that's probably fair to say. Be a great sort of law exam question here as to whether or not there was an offer and acceptance, but I ignore those editorializing comments because your time is actually up. So we have your briefs, we have your arguments. You know what the judge thought of the arguments, and we'll look at it de novo and consider everything. So thank you both very much.
Thank you very much.
Okay, so we have one more case to hear this morning. And that's case number 2023-0539, Angeliki Papadopoulos versus Norfolk and Dedham Mutual Fire Insurance Company.
Good afternoon, members of the panel. Constantine Papadopoulos for the appellant, Angeliki Papadopoulos. She's also the plaintiff and the insured. It's an honor to be here today. I'm grateful for the opportunity. I'm not sure where you want to begin because there's actually a motion involved here, and that is from the appellee's side. So I'm not sure if I need to start or the appellee, who's the one presenting the motion, needs to go first.
No, this is your appeal.
Okay.
Okay, so you can go ahead with your argument.
I think we do understand your argument and your opposition to the motion.
Okay.
Yeah.
I do have an argument, a separate argument, so that's where there's a little confusion here.
Okay.
As to whether I should be opposing the motion or actually.
Well, you filed an opposition to the motion.
I do, but I do also have an argument.
Okay, well, you can address, you can use part of your time to address that too, if you like. It's your 15 minutes to.
I'm sorry, excuse me, Your Honor.
That's okay.
I was actually hoping to argue that separately as, you know, I think it's kind of infected my appeal. I'm not sure what I'm appealing. Am I appealing the record below, or am I appealing two separate cases? So.
Right now, we're prepared to listen to your arguments with respect to your appeal from your case from that was brought in the court below. All right?
Appreciate that, Your Honor.
Okay.
Thank
all
you.
Right.
So the nature of the dispute here involves an insurance contract. At issue is a business owner's policy covering the premises 1 to 3 Commercial Street. That's issued by the defendant Norfolk.
Counsel, we have read your brief, so
Okay.
we're familiar with the facts and the
Very good.
basic arguments. Can I ask you this?
Sure.
I know your argument is the key date here was the date of the demolition of the adjacent building, and which, in your view, caused the damage to the roof and or the walls, and that allowed the infiltration. So when you're looking at the date of the loss of caused by the water damage, you go back to the date that the roof was injured. But just parsing out what the judge said, relying on the affidavit, I believe from your mother, is it your mother?
It is my mother, actually. That's the other thing I meant to mention.
Yeah. Relying on the affidavit and of your sister, they were there in April of 2017, and they didn't see any water damage. The judge took that and said, it's undisputed there was no water damage prior to April 2017. Do you, leaving aside your legal argument that no, you should have gone back to February, do you agree that the judge was within his or her, I can't remember which gender we're talking about?
First of all, it's a de novo review, and I don't agree.
No, but just as a matter of fact, does the fact that your mother and your sister saw no water damage, does that establish that there was no water damage in fact?
Absolutely not.
Why?
Because this is an insurance contract case, so you need to look at the burdens. There's different burdens at play here. So the insured's burden, this is the case law, is to prove coverage. That's number one. And if we go through the contract, I can go through the contract piece by piece.
Well, just cutting to the chase, the judge rested on the vacancy provisions. And they make the argument that those are conditions precedent to coverage, and therefore you have the burden. What's your counter to that?
I think that does not comply with basic insurance contract law. That's an exclusionary provision. I think you have to read the contract as a whole. I think exclusionary provisions are strictly construed against the insured. So once the insurer, I'm sorry, big difference. Once the insured satisfies their burden to show that there's coverage under the policy, then the burden shifts to the insurer to show that it's not excluded. Norfolk and DEDHAM has offered basically 4 exclusions under the policy, including the vacancy, and I can go through them piecemeal and piece by piece.
Why don't we start with the vacancy, since that's what the judge relied on?
So the vacancy provision, I'd actually like to go through the contract and show you. I was going to actually have the record, but I think if you start at 192.
Not a lot of time.
Okay. So the vacancy provision basically says if it's vacant, which we don't dispute, the building was vacant as of February 1. The demolition here, in this case, actually happened 2 weeks later. I think that's undisputed as well. So then there's an argument that the building's under construction. I don't even think you need to review that argument to find that the vacancy provision doesn't apply. So,
but isn't the key issue on the vacancy provision when the loss or damage occurred?
I think this is a train of events case. So you got to look at proximate cause, what caused the damage to the building. In this case law on that, it's well recognized, it's JUSM, but I also, and I can give you the site, I also think if you apply this contract with insurance contract law, these exclusions do not apply, and I can explain it. So number one, the damage, the train, so to speak, is the demolition. That's uncontested. That's the insured's claim here. That was actually never investigated. There's no evidence that the insurer actually investigated the insured's claim that the damage to the building was caused by the demolition. So then you go to the vacancy provision. Again, so first of all, the building is not, the damage caused by the demolition is not excluded because it's 14 days later. So then you got to go to Section B. You need to read the contract carefully. There's some minutia going on here, but there's coverage. And so it says where the building where loss or damage occurs has been vacant for more than 60 consecutive days before that loss or damage occurs. Well, guess the loss or damage here is the damage to the building caused by the demolition. So then you got to go through each of the exclusions that are within the vacancy provision. So number one is vandalism. It goes on and on. I think the appellee, Norfolk, agrees that only one of them possibly applies, and that's water damage, okay? So when you go, there's actually a water damage provision in the exclusions. So if you go to Section 1 of the exclusions, I believe that's on 206 of the record appendix. And this is interesting too because there's basically 2 sets of exclusions that can apply. One has an anti-concurrent provision. The other one does not. Number 1 has the anti-concurrent provision. Number 2 does not have the anti-concurrent provision. So, you know, by basic insurance contract law, that suggests there's a reason for it, and that's strictly construed against the insurer. So you go to number 1, and then you read water damage. There is water damage in that exclusion. None of it applies Certainly, there's no affidavits here to even support the insurer's exclusions. Nothing. There's nothing filed.
Can I go back to my earlier question, which is, your mother and sister did say, we were there in April 2017 and we saw no water damage. I understand your legal argument that with the train of events, et cetera, you go back to February, but put aside the legal argument.
Certainly.
Just look at the factual component.
Okay.
Was there anything in the record that established that there was water damage? Again, forget the legal tolling argument, that there was water damage prior to April of 2017.
No, the appellant, plaintiff, walked into her building on April 7th, believing there was no damage. She walked in there, didn't observe any water damage. And this gets into notice as well. So, like, why are you going to report it to the insurance company if you don't believe your building's damaged? Even the appellee, if you read their brief, they talk about water damages. You know, it could come in subtly. It could take time to observe. The appellee even acknowledges it in their brief. So, yeah, she walked into that building, and she did not observe any water damage, so she didn't report it to the insurance company.
Now,
who would? So,
does your mother's claim include a claim for damage to the roof itself?
absolutely. The roof, the walls, the parapet. I think that's another reason why, if you read the other decision, that it should not be incorporated into this case. One of the things the judge says in the other case is that the wall and the parapet were fixed in August of 2018. Well, great. I mean, the claim was asserted in February of 2018. So at the time, that wasn't fixed. The parapet was damaged. So was the wall. There's water damage in the building. If you strictly apply the burdens here, the burden is on the insurer to exclude coverage. Coverage exists. Coverage is the demolition. That's not denied. So they offered 4 exclusions. None of them apply. They haven't satisfied their burden. I mean, that's clear. The record's clear. If you look at the record in this case, the insurer failed to satisfy their burden. And then there's a 93A component of this case, 176D. There's no investigation. Absolutely not. It's a Section 11 case. It is
That's not fair to say there's no investigation. They did send out Mr. Talley, and
Correct.
he drafted a report based on his findings. You can argue that's inadequate, but there was some investigation.
Is one day where the insurance company visits the premises. I didn't say no investigation of the demolition. And if I did say no investigation, I misspoke. Absolutely, and it's undenied. They don't deny. It's an undisputed material fact. If you go to number 13 of the undisputed material facts, they acknowledge the insured's claim was that her building was damaged as a result of the demolition. So once you apply basic insurance contract law to this case, and you analyze the provisions of this contract, including anti-concurrent law, which is basic insurance contract law, there's coverage, period. And you know, these insurance policies have special meaning to an insured. It's protection. It's you have my back, you know, like in case I have a claim. And the meanings, ironically, I think, you know, the insurer understands the contract much better than an insured, okay? This case isn't about having your back. This case is about washing your hands. They didn't want to cover the damage. And that, I feel, is strong evidence that there is a 176D claim that should survive. And under the summary judgment standard, based upon the undisputed material facts that are before the court today, summary judgment actually can be awarded in favor of the non-moving party. That's 56C. So based upon the record here today, the appellant, I contend, is entitled to summary judgment. And that's the relief I asked for. Thank you.
Well, you have 45 seconds left, and I just want to review with you your impression that you were to argue your motion in opposition to file a supplemental appendix. Is that what you were talking about?
I'm sorry, Your Honor?
You filed a motion in opposition to their filing of a supplemental appendix. Is that correct?
I don't believe it should be included as part of the record, and I can address that.
No, you don't need to actually address that separately, or that's a motion that we take under advisement on our own. I just wanted to be sure that you understood that and you didn't feel as if you...
Well, I think there's separate and distinct cases. There's separate burdens, as I just showed. I don't think negligence that is caused by a third party is actually relevant to coverage. The coverage could be completely accidental.
No, we understand. What's before us is whether or not we're going to accept the supplemental appendix at all, whether we're going to look at it at all. And we will take that issue under advisement.
I appreciate that.
Okay? Just want you to know that that will be considered, even though you don't need to argue it, all right?
I have a whole argument against that. But thank you, Your Honor. I appreciate the time.
Good afternoon, members of the panel, and may it please the court. My name is Victoria Getz, and together with my colleague Miles McDonough, we represent the defendant appellee, Norfolk and Dedham Mutual Fire Insurance Company. We ask that this court affirm the grant of summary judgment by the Superior Court because the Superior Court correctly found that there were no genuine issues of material fact, and as a matter of law, Norfolk was entitled to summary judgment. We put a lot of arguments, different arguments into our brief, and I certainly won't get to all of them, but I'd like to start by addressing the grounds on which the Superior Court granted summary judgment, the vacancy clause. I'd then like to turn to two other grounds within the corners of the record.
Happy to have you go there, but can we just first address, to the extent their claim covered damage to the roof and the wall, then how does any of the judge's reasoning apply to that?
Well, Your Honor, to the extent that their claim applies to the roof and the wall, the notice provision would still preclude it, as would several other exclusions within the policy. With respect to the notice provision, it's also a condition precedent that when there is a loss, the insured...
So just the short answer to the question is, it's the notice provision that you would be relying on.
The notice provision as well as the speculative nature of those claims, Your Honor. The plaintiff has not provided sufficient evidence that there was actual damage to the wall.
Why is that? Her affidavit says that she observed tears in the roof membrane. Why isn't, I understand she's not an expert, but that seems pretty, why isn't that enough to survive summary judgment as proof that this may have been caused?
That would certainly be sufficient at a motion to dismiss stage, but at the summary judgment stage, her own personal belief that the demolition of the adjacent property caused damage is insufficient.
Mr. Talley, or if I'm pronouncing his name correctly, saw lots of debris on the roof, and that is at least suggestive that the demolition caused some stuff to go next door, and then coupled with the direct first-person observation of tears in the roof membrane, why isn't that enough?
Well, observing debris on the roof does not equate to damage, Your Honor. And additionally, I will get to this more extensively, but if the court does take judicial notice of the consolidated action...
Now, how is it that we can take judicial notice of evidence submitted in a wholly separate case?
Well, under Mass Guide to Evidence, Section 201, a court can take judicial notice at any stage of proceedings of adjudicative facts, such as evidence and findings of the lower court in the consolidated...
Take a look at Home Depot v. Cardis, which says we can take judicial notice of some aspects of a parallel case, but you can't take judicial notice of evidence in that case.
I'm not familiar with that case, Your Honor, but I am familiar with Reed, the acting commissioner of the Department Community Affairs, which said that adjudicative facts of which the court can take notice are the kind of facts that would go to a jury in a jury case.
These are facts that are being disputed. And for the life of me, I'm having a hard time seeing how you think you have a prayer of a chance to get us to look at facts in a different case.
Well, they're adjudicative facts that were contested. It was the same plaintiff representing those facts, adjudicating them when they're at issue in a related case arising out of the
And
same
they're under
event.
appeal, correct?
I believe there was a notice of appeal, but I'm unaware of any pending matter before this court.
Okay, why don't we turn to the vacancy provision?
Okay, yes, Your Honor.
Isn't the whole issue under the vacancy provision what date you use for the date of the loss or damage? And the plaintiff is arguing that, you use the original cause. In this case, according to her, the damage to the roof.
Yes, Your Honor, but there's two issues with that. First of all, as you pointed out during the plaintiff appellant's arguments, the plaintiff's own affidavit is that she entered the building on April 7th, 2017, more than 60 days after the vacancy, and observed no damage. And she hasn't put forth any actual evidence of when the damage occurred. Yes, the demolition occurred in February.
No, but her response to that would be, no, as a matter of law, if I have established that it could have been the damage to the roof that caused that, you look back to the damage to that. That set in motion the water damage, which wasn't observed until later. And that's a legal argument, not a factual one.
Well, the damage to the roof could have occurred in February and could have caused the water damage, but that's a condition precedent, which it's the plaintiff's burden to prove. The plaintiff, as the insured, bears the burden of proving.
Now, I hear you that for a true condition precedent, the burden is on the insured, but I've read this contract maybe 50 times, and I'm having a hard time seeing how this doesn't read like an exclusion or a limitation. It's about losing coverage if certain things happen. It isn't the plaintiff, the insured has to do certain steps or else.
Well, it falls, Your Honor, and it's on Record Appendix page 54 within property loss conditions. It is not found within the exclusions. But there are other grounds.
The word conditions itself just incorporates all condition precedent law?
It includes this condition precedent, but there are other grounds on which this court can affirm the finding of the lower court, putting aside the vacancy provision, including the notice provision, which I touched on before.
And the notice provision it seems like you are asking us to adopt new law, saying that you don't have to show prejudice.
Even if this court did find that we needed to show prejudice, this is a clear case where there is prejudice to the insurer. If we accept the plaintiff's version of facts, which again are speculative, based on her own affidavit, the damage occurred in February 2017, and it's not reported until February 2018 to the insurer, which means more than a year goes by during which there's a loss of information as well as damage to the property.
How do you deal with the fact that when you did have notice, it was a pretty minimal investigation of what was going on, and apparently no investigation of the alternative alleged cause, the roof?
Within 1 day of notice being provided to the insurer, an adjuster was sent out who inspected the property along with the plaintiff and her plumber and found sufficient grounds that this was not a covered loss. And on that, the insurer was able...
Wasn't that on the vacancy provision?
It was, as well as the continuous water seepage. And I believe there's alternative grounds if you look at the statement.
Well, let's talk about the continuous water seepage. Tell me if I'm wrong. Your client in the summary judgment motion was relying on admissions from the plaintiff and other uncontested facts, but did not itself put in affidavits or other material to try to talk about what caused the water damage. Is that fair?
That is accurate, Your Honor. We felt based on the record, including the plaintiff's own statements, there was sufficient
So we
grounds.
don't know, do we, on this record, whether there was 14 consecutive days of seepage or not? We don't really have much idea at all how this happened.
Well, the 14 days of continuous seepage is included in the adjuster's report, who said that that was his observation, as well as if you take the plaintiff's own contention, it's that this was seeping for a period of up to a year.
I'm not sure she was saying it was continuous. It was, maybe it's when the rain blows in the wrong direction or something. Who knows? But let me address the point that the plaintiff made, which is that exclusion is included in the second set of exclusions. The first set has this provision that its avowed purpose appears to be to negate the chain of causation problem and saying it doesn't matter what order it's in. If there's a covered loss, a cause of loss, it doesn't matter for these exclusions. But that language does not appear with regard to the water seepage exclusion, which, why can't that then be interpreted as the water seepage exclusion, you still apply the chain of causation argument?
As to the factual issue of it, the provision is continuous or repeated seepage. So even if it was that this was going on and off for a year when it rains or the wind blows, that still falls within this. But as to the covered cause, it's the plaintiff, as the insured, bears the burden of proving that it falls within a covered clause once the insurer says this is an exception. And they haven't done that here. The plaintiff had the burden of proof, and this is at summary judgment stage, to put forward sufficient evidence to establish that.
Why isn't the damage to the roof, which is established by the affidavits, and frankly, I don't remember exactly what the tally report said, but there was stuff in there that was consistent with the plaintiff's theory of how the damage was caused. Why isn't that enough to survive summary judgment? I'm not saying she's going to win at trial, but...
Because it's based simply on the plaintiff's own speculative beliefs that there may have been damage and tears to the roof which caused this. It's insufficient at a summary judgment stage to have the plaintiff's own subjective, after-the-fact belief that this is what occurred.
If there's a tear in the roof, you don't think that that is a quite possible cause of the seepage into the walls and ceilings?
I think it's certainly possible, but that's insufficient at a summary judgment stage to say, I believe that this demolition caused this tear, which maybe caused the water to seep in. But again, the court doesn't need to get there. If you look at the notice provision, this is an instance in which the insurer was actually prejudiced by taking the plaintiff's version of events, a 1-year delay. That passage of time, a whole year, is the loss of information to the insurer. And in a case such as this, and many other property contexts, there's no outside information available to the insurer to investigate what occurred. There's no fire reports, there's no police reports, there's no witness reports, because no one's at the property. And again, water damage by its nature, and we cite a Florida case in our brief for this, spreads over time.
Is it your argument that your prejudice is self-evident?
Yes, Your Honor. Due to the nature of the delay and the nature of the damage here.
Well, wouldn't there still be available to the insurance company to speak with or interview the people who conducted the demolition and the town and other people that were responsible and the different reports that came through at that with respect to that process?
No, Your Honor, because none of those people go inside this property. This property sits unopened for a period of 9 months where there's no one coming in and no information available to the insurer. What's happening next door doesn't bear on what's happening inside this property and whether or not it was in fact a covered loss. The plaintiff herself puts forward multiple different avenues for how this loss could have occurred.
Is there a dispute about whether or not there are any tears in the roof And then I know there's no dispute, even your expert, or investigator said that there was debris up on the roof. Is it a dispute whether or not there was any tears in the membranes and things like that that were visible?
I would submit that there are, as our expert's report is silent as to any tears which otherwise would have been noticed. The only evidence of tears comes from the plaintiff's affidavit. Her own roofer report fails to actually connect the demolition to the damage inside the building. He says there are code violations and there is water damage, but he doesn't actually explain how these code violations lead to the water damage inside the building, which is, again, insufficient at a summary judgment stage to make it through when the plaintiff bared the burden of proving that the claims fall within the scope of coverage provided by the policy, and that's well-established case law.
There's very little time left, but I have to ask, could you spend 30 seconds on addressing the alleged conflict of interest that the plaintiff raises with respect to your firm representing both the insurer and the party who's a defendant in the other case?
Certainly, Your Honor. We would submit that there's no conflict of interest. This is not the type of case that would mandate a withdrawal of our firm in one case or the other. And such a case would be where the zealous representation of the two clients would be compromised, and that doesn't exist here. And I would refer the court to the recent decision, Tran v. Liberty, from this case. This was two separate causes of action, and both of which looked like they would resolve and lend themselves quickly to motions for summary judgment. So there was no conflict of interest. I see that my time is expiring.
Yeah, it's not a question, just a comment. You can tell we find this case interesting, and we will do our job of resolving it. At least one of you is going to be unhappy with that ruling, however we come out. And I say at least because both of you might be unhappy with what we do. With that in mind, as we do our job in resolving this appeal, there's nothing preventing you guys from continuing to talk and potentially resolving this, because at this point, unless I'm missing something, we're just talking about a number. And you guys are better equipped to deal with that than I am.
And I'll add that you both presented your arguments very well on both sides. We appreciate it, and that's partly what probably leads to Justice Milkey's astute observation.
Thank you very much, Your Honors.
Thank you very much. Okay, that's our last case, since we're finished for the day. The court will stand in recess.